All right, a very pleasant good morning to everybody. I'm Jeff Solomon with the Community Association Resource Group, affectionately known as CARG at cargforhelp.org. We're about to get started with an excellent presentation. Our main event speaker will be announced in just a moment. This is everything you wanted to know about association collections and foreclosures.
Good morning, Jeff, and good morning to all the participants, and thank you so much for joining us. CARG is a community resource group, basically, that offers homeowners and board members, property managers, education, free advice, and obviously, if you'd like to go ahead and to do anything further, obviously, they're well-vetted individuals that primarily handle community associations. Just to go ahead and get some of the housekeeping out of the way, today we have Charles from GRC Landscaping. We have Craig from Professional Builders, Andrew, which is, especially now I'm looking out the window with all the rain coming up. We basically have a lot of I just lost my thought. They have because of a lot of rain, obviously they're very busy. We also have Catherine on from as a public adjuster. What I'm going to do is, just for like literally 10-15 seconds, I would like to just have each of the COG members that are on right now just say hello, introduce yourself. And then what'll happen is, at the end of John Stevens' presentation on collections and foreclosures, the CARG members will stay on and obviously answer any questions that you may have. And then we can go from there. So Charles, if you can start off. This is Charles from GRC Landscaping. If you can just introduce yourself, tell you what you do in about 10 seconds.
Good morning, everyone. My name is Charles with GRC Landscaping. GRC Landscaping is a full-service lawn maintenance, irrigation, and tree trimming company serving the Tri-County area, and we've been in this business for the past 17 years.
All right, thanks, Charles. And then Catherine, you just have to unmute yourself.
I got it. Hi, how are you? My name is Catherine. I've worked with community associations in order to file insurance claims and review if it's worth it for the associations to file insurance claims for over 5 years now. And I'm available for any questions after.
Great, thanks so much. And next is Craig with Professional Builders. Craig, I think you have to unmute yourself. And Craig may have gone ahead. No.
He may have stepped away, Mark. Let's move on.
So let's go ahead. Darren, can you unmute yourself? And Darren is with one of those pesky control companies.
Good morning, everybody. Darren, Forever Gone Pest Control.
All righty. Let's see. Do we have anybody else right now?
Nobody else, Mark. Tell them about yourself and your company.
So just very quickly, my name is Mark Buckhalter. I've been doing condominium accounting, the monthly accounting, for over 20 years. And I'm going to be moderating your presentation. So what I would like to do right now is go ahead and introduce John Stevens. He's the founder of Stevens and Goldwyn. He's been around forever, even though he looks very young. He's just John. I've known John for probably 25 years. Just a super nice guy. He's like my go-to person when I want to give a call and find out some advice. And what I also like about with Stevens and Goldwyn is they don't really nickel and dime. If you give a call and it's just a few minute call, the clock doesn't start ticking. They don't start billing you. Unlike a lot of other law firms. So he's just a real gentleman to deal with and very knowledgeable. So with that said, John, I'm going to leave it to you to go ahead and to start the presentation. After you're finished, then we'll go ahead and read any questions that the audience may have, and maybe you can help them out with that. And then after that, like I said before, we'll open it up to the COG members. So if you have any questions on any of the items that are on your agenda that you just need a quick answer to, we'll try to help you out. So John, take it away.
Thanks, Mark. I really appreciate it. First, I want to thank Mark and CARG for having me. These types of events are fantastic. I am a strong believer in education. I believe that the more education board members have, the more education property managers have, the better that we can all do for our associations. And I truly want to thank CARG. I think they're a fantastic resource. The fact that each of these people open themselves up to the community with their specialty to answer these types of questions is absolutely amazing. I use them as a resource myself. I find times where I'll call Mark and other members of CARG to ask them questions about issues that I have in my communities that they specialize in. So I do want to take the time to thank them for providing this type of forum. I think it's absolutely amazing. So with that, let me tell you a little bit about myself. I am an attorney. Not a lot of people like attorneys. Even myself, I don't like a lot of attorneys. So, I'll try to make this as enjoyable as possible. I've been practicing law for 26 years. I am, unlike Mark said, my daughter would disagree. I look old. The camera, maybe I'm far enough back where I look young in the picture. I've been doing this. I started right out of law school, representing condominiums and homeowners associations. I currently represent a little over 600 associations throughout the state of Florida, predominantly in Dade, Broward, and Palm Beach County. My largest association is here in Broward County. It's 5,200 homes plus commercial. So it's close to 7,000 units. By the time you're done, it is one master association and 30 sub-associations. I also represent a lot of large HOAs in the 4,000 and 5,000 unit range. And my smallest association happens to be 4 units. So they go from 4 to 7,000. I have seen everything. I get calls daily and about all kinds of issues. Foreclosures and liens and collections happen to be kind of the bread and butter of the association industry. And I want to talk a little bit about that today. I think that this is a really important topic, and while we're not going to talk about these issues today, I do kind of want to raise some issues as a backdrop for why I think it's so important that you guys know about the foreclosure and lien process. So as we all know, especially in condominiums, there's been changes over the last couple of years as a result of the collapse in Surfside that has made changes to the statute, which are going to require structural integrity surveys. They're going to require associations to fully reserve any structural items. There's been changes in the HOA statute in terms of certain items and how you can enforce your collections. And so with all of these changes in the statutes, especially in the condominium area, I truly believe that starting next year, we're going to see a rise in collections. In condominiums is you can no longer waive reserves in certain condominiums, when you don't have to pay for these structural integrity surveys, when you have to pay for these reserve studies. These are going to be a lot of additional expenses that, especially out west, where you have a lot of 55 and over communities and a lot of low rises that are 3 stories and above, but they're not these big, expensive high rises on the beach. You're going to see a lot of people are not going to be able to afford their maintenance going forward. And so I really think we're going to see a perfect storm in the next couple of years that give rise to a large collections opportunity. And so it's really important that you as an association have a plan going forward and that you know how you're going to deal with this lack of income coming in. So with that, let's start talking a little bit about collections and what happens. So this is really, if you don't have money, right, and it makes sense. We have this in our own lives. If we don't have money coming in, we can't pay the bills, right? We can't we can't pay to keep the property up. We can't pay for the nice pool. We can't pay for anything. And this can cripple and destroy our associations. A lot of us saw this in 2007 and 2008 when we had the real estate market crash. We're not there yet, but as I explained, for other reasons, I really think that this is going to start happening more and more going forward. So I always tell everybody it's a little counterintuitive for my board members. You know, I have board members come up to me and they say, look, we don't want to send demand letters to our residents. We don't want to file liens against our residents. We don't want to do foreclosures because these are our friends. These are our neighbors. They're hurting. We just want to let it sit for a while and hope they catch up. And I'm going to tell you, having done this for 26 years, that's absolutely the worst policy that you as a board member or you as a manager could ever take. The more money someone owes, the more time that goes by between them paying and you attempting collections, the more difficult it makes them, the more difficult it makes it for them to pay. The more money they add up, the more late fees, the more interest, the larger the balance, it becomes very, very difficult. So when someone doesn't pay, they typically just stick their head in the sand if you're not coming after them. Why? Because it's human nature. If we owe some people money, if I'm not making money, we're going to pay the people that bother us the most first. The greasy wheel always gets taken care of first, right? So, or the squeaky wheel always gets the grease first, right? So if it's you don't pay your phone bill, they shut off your phone. If you don't pay your car bill, they come and they take your car. They don't pay your mortgage, they foreclose on your house. So we have to show that we are going to be that squeaky wheel. We're going to be aggressive. We're going to move forward faster than the phone company, faster than the car company, faster than the mortgage company, to educate our residents that they should pay us, the association, before they go and pay anyone else, because we can unfortunately make their lives difficult in a very quick way. And so you have to educate them, teach them expectations. And if we just ignore the situation, their expectation is you're going to ignore the situation and you get put on the bottom of the list. And so that's not good for them and it's not good for you. So in order to make sure that we move forward in an expedited manner, we need to set up an action plan. And it's very important that we're very consistent, okay? We don't want to treat different people differently because they're our friends or our neighbors, opposed to that one person in our community that we all dislike. We want to treat everyone identical. For instance, with settlement agreements, I suggest that the association come up with a standardized settlement agreement they're willing to take on any situation. I don't think that you should make a habit of forgiving fines or late fees or legal fees. I think you should collect as much and all that you can. And that if you have to, you should work with people going forward. But I suggest that you have a one set plan. For instance, I typically recommend a settlement agreement of no more than 6 months at this time, with a payment of 50% down and the balance over that 6-month period. Okay. And if you are going to work out something, you should always have it done in a written agreement that is signed by the parties. I suggest you have your attorney draft that for you. Okay. So if someone doesn't pay, what are our options? And I do want to point out that we've had a lot of changes in the last couple of years where, as we go through this, I do want to point out, and this also goes back to the first slide where I say that you have to move forward in an expedited manner sooner rather than later. The reason for that is that the state has added so many layers of letters and timeframes that you have to do as a condition precedent to taking any action on collections. So you have to understand what it is you can do and when you can do it, okay? So let's talk a little bit about some of these things. But before we get into what we can do in collections, I do want you all to look at issues related to bankruptcy. So if someone hasn't paid their bill, the first thing before any of you take any action for collections, you need to double check to make sure that they have not filed for bankruptcy. Because if they have filed for bankruptcy, taking any collection action against them can be a violation of federal law and you can be fined for it. So you do not want to be that association or that management company that is sending letters to the person that is in bankruptcy, and then you get called before a federal judge and they issue sanctions against you. It happens all the time. So if they're in bankruptcy, you want to make sure that you contact your attorney and that the attorney takes action in the bankruptcy court to get permission for you to take collection activities before you do anything. Okay, so it's very, very important that you look into that. So the next item that you want to look at if someone isn't paid is the property vacant, right? You want to know, is someone occupying it? Is it leased? Is it owner occupied? And the reason for that is if it's leased, the association has the right under the statute to then go and send a letter to the resident telling them that you're going to collect the rents against the tenant. Okay. And that tenant then has to pay you those rents. And if they don't pay you the rents, that you have the right to then go and evict them from the property. If the property is vacant, you may be able to finish the foreclosure and then quickly go and rent the property on your own. So that might be a great reason. That's a great reason to look at the vacancy, because you may have the opportunity to collect all this money back by taking title and renting the property. Okay. Again, as I talked a minute ago, there's a section of the statute both in 720 and 718 that provides that we send a certified mail letter to them telling them they have to pay the rent to us. And if they do not pay the rent, then they're subject to eviction. And the association can act just like the landlord and file an eviction against them. Okay. You also have the right to suspend their use rights. This would be suspending their rights to use the gym or use the pool. What I want to make sure that you understand, and I do get a lot of questions about this, is that this does not include your right to suspend their use to gate access. So I have associations calling me all the time that say, look, we'd like to suspend their right to use our guest gate or our owner's gate and make them all come through the guest gate so they have to check in. And there's some ambiguity in the statute. I know some attorneys have said before that this is okay. I will tell you that my experience and my suggestion is that you never try to suspend their gate access even through the owner's gate, even if you're allowing them access through the guest gate. The reason, I've had several lawsuits against associations that have done this against my opinion, where they have lost pretty badly, where the association has been sued for not allowing access. And I have had judgments entered against some of these associations where they were told not to do this and they did it anyway. So you need to be very, very careful with suspending access to the property, but you can suspend use rights to things like the pool, any other type of amenities that you have there. But you have to give them notice and an opportunity for a hearing. Okay. Again, also payment plans. I believe 6-month payment plans are better than 12 months. I would never suggest that anyone go more than a 12-month payment plan. And I always suggest that you ask for a very large down payment. People that ask for a very small down payment generally cannot make the payment plan. That's just my experience. If they say, I can't make a down payment, or I only want to make a monthly down payment, my typical belief is that they're not going to be able to live up to the payment plan going forward. So again, I suggest payment plans in writing. They should have provisions in there that if they default under the payment plan, that you don't have to take any further action to do your lien. So for instance, you want to make sure that the statute of limitations is waived in it, so that if your lien goes longer than 1 year or 5 years, depending on whether it's an HOA or condominium, that it's not going to end your lien. You want to make sure that they waive issues of service of process. You want to make sure that they agree to hold you harmless from any of your collection activities. You want to make sure that they're going to make the monthly payment plus keep current with you. So all of these are items that should go into your settlement agreement. It should be written. It should be signed by all of the owners. So look, if you have a property that's owned by 2, 3, 4 unit owners, I see a lot of associations just get one unit owner to sign You absolutely do not want to do that. You want to make sure every owner signs the agreement so that you can fully enforce it. Okay. One of the next things that you really want to look at before you file any lien or foreclosure actions, you want to see whether or not there's a bank foreclosure. Okay. And the reason you want to see whether or not there's a bank foreclosure is you want to see how far along it is, see when you anticipate them taking title to the property, and determining if the bank has done anything, if they've been paying the bank, if they haven't been paying the bank, and it'll help you determine your next cause of action. Also, I strongly suggest that every association, when they're served with these bank foreclosure matters, turn them over to their attorney to file an answer. A lawyer should always look at these complaints. Give you a great example. I had an association management company that was served with what they thought was a bank foreclosure complaint. It was not a bank foreclosure complaint. It was a several $100,000 lawsuit against the association. They did not send it to the attorney because the association's instructions were they didn't want anything done with the bank foreclosures because they did not want to be charged for an attorney looking at it. So this foreclosure complaint in their eyes went in a circular file until a judgment was entered against them for $600,000. And then they freaked out and needed to take action to try to fix that. So it's very important that when you're served with any type of complaint, that you have an actual attorney, not just your manager, not just the board, take a look at those complaints that are served on you. Every association in a bank foreclosure is served with the bank foreclosure complaint because you are a junior lien holder and you have the right to participate in that action. I strongly recommend that you do because it will help make sure that you can move that bank foreclosure forward. If you don't answer and you don't participate in the bank foreclosure, you really lose your status of being able to go into the judge and say, why is this taking 2 years? Why is this taking 4 years? We need you to move this case forward. And also, you want to be in the bank foreclosure because you want to make sure if they're not the first mortgage holder, that that's set forth in any judgment, because then you may be entitled to more money and it may be substantial. Okay. So let's talk a little bit about our money that's now due, our assessments, the association's assessments. So there's some new requirements, and by new, I mean within the last 2 years, that the association cannot change the manner in which they deliver their statements unless they notify the residents. So before you change the method of delivery, you now have to tell the association owner at least 30 days in advance. You have to send the assessment or statement of account by first-class mail or electronic transmission to their email address as maintained by the association. And you can only send it to that email address if they've opted into electronic notice. So the unit owner would have to sign a separate document authorizing you to send them electronic notice. Okay. And that's very, very important. So one of the things now is we all have these portals that we sign into. I strongly suggest that you have a box on the portal, and someone who's more fluent in more knowledgeable in computers and technology can discuss this with you, but that when you log into the portal and you fill out information, it should have an automatic place for you to agree to electronic transmission of notices. So when I'm putting in my information for the first time with my name and my address, my telephone number, and my email address, I really like it to have a screen that comes up where they check off saying that they agree to all future electronic transmission. So I think that's very, very important to kind of do. Okay. So let's talk a little bit about what happens now. So I'm going to use myself as an example. I didn't pay my association fees. What happens to me? Well, I've received my statement, came to me by my email address, which I've agreed to receive the electronic transmission, and I just didn't pay. So what happens at this point? The association has to send a 30-day courtesy notice of late assessments. Okay. So the courtesy notice of late assessments has to be done now under Florida law before any attorney's fees can be charged. And I know companies like Marks that do accounting will do this for you. A lot of managers will also do this for you. And on occasion where we have associations that don't have companies like Marks or managers that are willing to send the letters, we will send them for you as well. But right off the bat, you have to send a 30-day notice. Okay, and this is just, I'm going to go over some of all of this in detail. This is just kind of a highlight of the steps that we go through. So the next one is typically, I recommend after the 30-day notice, it would be sent to our office, and then we go through the process of sending out the demand letters, liens, and foreclosures until the association pays. So this is kind of a rough outline of how this works. Okay. So again, the 30-day notice, it has to be sent to them at their last known address. I do also want to make sure that, again, talking about each owner, one of the main things I see when associations do this, or sometimes even their managers, and I think some of this has to do with the computer system that is being used, depending on which management software is being utilized, is that it has to go to every single owner. So one of the big mistakes I see is that it picks up, typically the software will pick up the first 2 owners, but if there's 3, 4, 5, 6, 7, or 8 owners, it leaves everybody after the second owner off of the delinquency notice. So it's very, very important that the notice go to every owner, and it goes to the last known address as made and maintained by the association. I also typically recommend that if it's going to an address other than the property address, that you also send it to the property address. And you also have to remember that people may have multiple addresses that are on record with the association. So it's very important that it goes to every address that you've been notified of, because failure to do any of these items correctly can result in your entire collections process being wrong. And you may find that out several years down the road. And if you do it wrong and you sue them, you may be subject to being sued under state or federal law for improper collections activities. So it's very, very important that you do it properly. Okay. Also, when these letters are sent out, there has to be a sworn affidavit signed by either the board member or the manager or their agent, attesting that the mail was sent and where it was sent to. Typically, you should do one of these for each letter that is sent out. So if you're sending a letter to me, there should be an affidavit from whoever sends that saying it was mailed to my address, the date it was mailed to, and how it was mailed. Okay, this is kind of a collection sample. This is what that kind of initial 30-day letter would typically look like. As you'll see, it says, "Dear John Doe." It has the name of our association. It has the account number, if any, and it sets forth specifically the amounts are due and the date through which it's due. So here it tells us exactly the amount. It tells us the exact amount of the late fees, and it gives us the total. And it tells us that you have to pay this, and before, if you don't pay it, something's going to happen. It's going to be sent for further collections. Okay, so this is a sample letter that you can all see and utilize the 30-day letter. So the next letter, so we now have 30 days on our list, right? The next letter is that we have to send out a 45-day notice of intent to lien letter. So I've now sent this 30-day letter, 30 days have expired, and the person still has not paid. So now the state has decided, okay, the 30-day letter isn't enough. Let's now send them another 45-day letter. So we now have to send this second letter. This letter has to go certified mail, return receipt requested, and first class U.S. mail. It has to go to the last known address of every single owner that's made and maintained by the association. It also has to go to every owner. So if you have multiple owners and multiple addresses, you need to make sure you do that. This can become also quite expensive for associations because it's about $8 and change for every single certified letter that you send out. So if you have properties that have multiple owners and multiple addresses, you could be really charging up some mail costs here. The letter must provide the unit owner 45 days to pay. Okay, so that's the notice of intent to lien letter. So this is a sample copy of it. Again, It tells you what you have to pay, who you have to pay it to, that you have 45 days to pay it, and that if you don't pay it within 45 days, there'll be a lien posted against your property. And for this letter, unlike the 30-day letter, you can also charge attorney's fees for this letter. So this could be sent to your attorney, and they could bill the delinquent resident attorney's fees as it relates to the collection activity. So now we have a 30-day letter, and the next letter, our 45-day notice of intent to lien letter. So what comes up next is our second letter. So now the legislature has decided we need to send another 45-day letter, and this is our notice of intent to foreclose letter. So now we have 30, 45, and now we have another 45-day letter. And this letter also includes our claim of lien, which we're going to go through here in a second. But it says, look, you ignored our 30-day letter, you ignored our 45-day letter. We're really, really serious about this. Attaches a copy of our claim of lien, and if you don't pay it within 45 days, then we could file a lawsuit against you to foreclose on your property. Okay. Again, you can charge attorney's fees and costs for this. However, if you do not send this letter, you are not entitled to recover attorney's fees and costs in any subsequent foreclosure battle. So it's very important that this letter be sent, because otherwise you're doing all of this and you're not going to recuperate any of the money that you put out for the foreclosure process. Okay. So this is a copy of a sample for this notice of intent to foreclose letter. Basically, it says we've attached a copy of the claim of lien. You haven't paid it. You now owe X amount plus attorney's fees. If you don't pay it, we're going to file a foreclosure against you, and that you have 45 days to do that. Okay. It also has to tell you where it's going to go. And if it's being done by any third party, so other than the association, if it's being done by the manager or an agent or an attorney, you need to make sure that you include a Fair Debt Collection Practices Act notice, because they are considered debt collectors, and you need to make sure that that notice is also included. Okay. So now we file a lien. Okay. So what is a lien? A lien is a document that's filed in the county in which the property is located, and it puts all of the world on notice that money is owed. So ideally, it would stop the sale or transfer of any property without you being paid. Even if it doesn't stop the sale or transfer, so long as a lien is filed, that person is on notice, and so therefore they would owe all of the money as well. And it is a prerequisite for filing of the foreclosure. So once the lien is filed, now the collections process works almost just like a mortgage foreclosure action, right? So the lien acts is basically just like a recorded mortgage would act against the property. It's everyone on notice of our priority on the amounts that are due on the property. Okay, so how long are these liens good for? So this is one of the things I was talking about in the settlement agreement. Condominiums must file the foreclosure within 1 year of recording the claim of lien. That's because the condominium statute in Florida makes the condominium lien only valid for 1 year. If you wait longer than 1 year, and this also goes back to the very first slide that we talked about in the beginning of the class, that you want to do things sooner rather than later. I can't tell you how many associations that I have represented over the years that get all the way through this process. They've sent all of these letters, they've spent all of this time, they filed the lien, and then they absolutely refuse to file the foreclosure. And 1 year goes by, and they call me up after, even though we send requests every single month for people to go forward and we tell them this date is coming. They call me up and they say, well, what do we do now? And I tell them they have to restart the entire process again, because the lien is no longer valid. And so if they want to eventually foreclose, they're going to have to go through this entire process and start over. So it's very, very important that you move forward expeditiously, because after 1 year, you got to start over. Okay. In a homeowners association, it's 5 years. So 5 years, much longer. We don't usually see HOA liens expire as much. People within 5 years have usually decided that they're going to do something. But 1 year for a condo, 5 years for an HOA. Okay, here's what a claim of lien looks like. It has to have in the corner who prepared it and where it should be returned, because the originals are always returned to you. It used to be that we would have to drive these down to the local county recorder's office here in Broward that's downtown. And we would actually physically go in and the recorder would record it and stamp it. When I started, these were actually kept on microfiche, and we would go down and we'd have to look in the big machines and see them. You couldn't see them online. Now we don't even go down there. We have a scan system. We scan it in at a desk in my office, and they're just automatically recorded. We do all of the recording information in-house, and basically now they don't have to do all the work. We do it all, and it appears shortly thereafter. But it has the name of the person who prepared it, the address where it's to be returned to, the name and address of the association must be included on the lien. We typically put the address as our own. This because many associations don't want to have their address out there. And then it has to have the legal description of the parcel. So the only way the lien attaches to the parcel is by having the formal legal description. This is the same legal description that's in the deed to the property. It has to have the name of all of the owners of the property. It has to have the amount due and the due dates for those amounts. This is always a touchy section on the lien. So as many of you know, the statute says when someone pays, it's applied first to late fees, interest, attorney's fees, collection costs, then the oldest balance forward. So my belief is that the due date is always the last date on the ledger, because these monies always flow through. Some people argue, a lot of defendants try to argue that they need to know when each payment was missed. I very rarely see a judge side with that. Sometimes it can cause confusion. So one of the things that can be done is you can actually attach a copy of the ledger. The only problem with that is that while it does give the ledger there, and therefore we have a clear accounting attached to it, you're being charged more because they do charge per page for recording. So a lot of associations don't want to pay that extra recording cost. It has to include any attorney's fees that are being charged for the lien on it. If any title exam is being done, it has to break that out on there. And it has to specifically set forth on there the mailing charges that are being charged. You can see this one is old. It's $572. I don't think they've charged us that for mail for a while now, but has to have the mailing costs. Has to be signed by the association or an agent of the association, and it needs to be witnessed and notarized just like a deed. So what the law says is that a claim of lien has to be executed in the same manner as a deed. Okay, so this is what a claim of lien looks like. So now we've sent our 30-day letter. We've sent our first 45-day letter. We've now sent our second 45-day letter, and we've liened the property. So now what options do we have? Well, now after that second 45 days have expired, the typical suggestion is to file a foreclosure. Again, this foreclosure works just like a mortgage foreclosure. Okay. The ideal situation is that someone pay you. So you file the foreclosure. And I'm going to tell you this happens quite a bit. We file these foreclosures and the resident's like, oh my God, I didn't realize they could actually foreclose against me. I'm now going to work out a settlement, or I'm now going to pay. Okay. The other option is that you get a judgment against them, and we go through this entire process. I'm going to talk a little bit about it in the coming slides, but we go through this entire process and the property is sold either to you or to a third party. And then if it's sold to a third party, we can go after the third party. The third party would have paid all the amounts that are past due to you, so you become whole. So let's talk a little bit about some of the process. So if they don't pay, we've gone through all of this. We file the lawsuit. They have 20 days to serve. Once we've served them, they have 20 days to answer our complaint. So here's like a brief example of the front page of what a complaint looks like for lien foreclosure. This is then personally served on the defendant. Once it's personally served on the defendant, again, they have 20 days to respond. Sometimes we have problems serving, so we have to go through a publication process. And under that circumstance, we publish in a newspaper. And after we've published in the newspaper, we then file that with the court. And then the court deems that's been properly served on the defendants. Once they've been served, they then either answer the complaint. If they have not answered the complaint, then we can move for a default. The default basically is just saying that they haven't answered and that we're entitled to a judgment as a result of their failure to answer. After the default or answer, we either move for a motion for summary judgment if they've answered, or a default judgment if they've defaulted. Basically, a summary judgment motion says that if you look at all of the facts and law, there's nothing that they could argue that would allow them to win this case, and that we're entitled to win as a matter of law. And lots of times the courts will enter a judgment at this point in favor of the association. Motion for default final judgment is saying they failed to answer the complaint, and therefore all of the allegations of our complaint are true, and asking the court to issue a judgment in our favor. So either way, if we win on summary judgment or we win on a motion for default summary judgment, a judgment is entered and a sale date is given. Okay. Now, when I started practicing the law, I'm sure all of you've heard, this is going to be auctioned on the courthouse steps, it's going to be sold at the courthouse steps. This literally was auctioned on the courthouse steps. They would roll out a podium, the front of the courthouse on the steps, and people who wanted to buy these properties would come and they would bid on the properties in $100 increments up to the judgment. And they had an auctioneer, and people would raise their hand and they would bid on the properties. And eventually, too many people were clogging the front of the courthouse. They moved it inside. They got their own room. And now none of that happens. Now we sell it on the internet, kind of like eBay. Everybody has to register. And then you tell the computer the maximum amount that you want to bid on the property. And the computer then bids in $100 increments against the other computers until it reaches the highest bid. And that person is the person that is successful in purchasing the property. So with an association, if you have the judgment, you have a judgment amount. I always suggest the association bid up to that judgment amount. If nobody else bids higher than that judgment amount, then the association becomes the owner of the property. And then we have the ability then to go either rent the property or try to sell it to someone subject to the first mortgage that's on the property. If someone bids above the judgment amount, then you've been paid, and that's fantastic. So now you have someone that's come in, they paid you in full, and now you have a new owner on the property that is presumably going to take care of the property, pay you going forward. And or if they don't, you can certainly go after them, and then hopefully they have assets, and usually they do. I will tell you, we're very, very successful, and most people are very successful in getting these properties sold to third parties now, given the state of the market. And the fact that it's done on the internet. We have people buying these properties from all over the world. And so we're seeing most of the properties are sold at the auction to a third party. And once the property is sold either to a third party or to you, the association, a certificate of title is entered, and that acts as the deed to the property. And you are now the new owners of the property, and they're the new owner of the property, and they have to take care of it just like any other owner. If there was a first mortgage on the property, these sales are always subject to the first mortgage. One of the big questions I get from my association clients is, does that mean that we're personally liable for the mortgage? And the answer is no. You are not liable for the mortgage. They can never sue you to pay that amount, but their lien against the property continues, and they can then continue with the foreclosure, and they can sell the property out from under you. Okay. So this is what a final judgment looks like. Here, basically, it has the name of the parties, the case number, the amount that's due, and the date of the sale. Here's what a certificate of sale looks like. So this document is basically the sales occurred. It tells you who the purchaser of the property was, how much they bid for the property. So this is always filed after the sale. And then this is what a certificate of title looks like. Again, this is the title to the property that's going to be recorded in the county. It has the legal description, and it's signed by the clerk of court, and it tells you who the property owner is. Okay. So one of the other things that is very important to keep in mind is that both the HOA statute and the condominium statute say that liability, the new owner that acquires title of the property is jointly and severally liable with the prior owner for all past due amounts. So this gives you the ability that even if there's a new owner and there's unpaid amounts, potentially to go after them for these other amounts that were also past due. Also, if the property is sold at any time during this process, it gives you the ability to go after the new owner for anything that was due and not collected, so long as you didn't falsely do the estoppel and put in estoppel lower than it should be. If you mess up the estoppel, you're stuck, unfortunately, with the amount of the estoppel. Also, you want to make sure that your documents, one of the things that you want to make sure that you do and have your attorney do is you want to make sure that there's no provision in your documents that change the statutory liability. A lot of older associations from the 70s have provisions in the documents that say that if anyone purchases at a foreclosure sale, they're not responsible to pay any amounts. This is also very important when you're looking at bank foreclosures, especially because a person buying at a bank foreclosure has to pay you 12 months or 1% of the mortgage when they take title to the property. So if you have a provision in your documents that says that they don't have to pay you anything, that provision in the documents may actually prevail and you may not get any money. So it's very important to look at this joint and several liability issue and what your documents have in it. Okay, so again, I kind of went over this. I'm not going to go over it again. If you guys have questions about it, you guys can talk and ask me in the questions section. But what are some of our other legal options? So as I said earlier, we can foreclose. If we don't want to foreclose, we can actually sue them for a personal judgment. So we can go get a personal monetary judgment against them. I see very little reason for doing this unless someone has moved out of the property. So for instance, if someone has just abandoned the property and it's in bad shape and you're never going to get your money out of it, you can sometimes go after personal judgment. This typically only works if you're suing an investor. So lots of times what will happen is you'll foreclose on an actual resident. You'll get paid everything at the foreclosure sale, and then an investor will have bought it and they'll just decide over time not to pay you. Sometimes when that investor has not paid you on that second round, a personal judgment does make sense because they have assets and you can go after them under a personal judgment. If they have a tenant in the property, again, you can go after the rent and you can send a rent demand letter. And if they don't pay the rent, you can file an eviction. And so there are lots of different things that you can do to try to collect money. We send letters and demands and calls and take all of these actions. Pretty much you should try to do everything you can to collect these funds. Okay. So again, I talked a little bit earlier about these bank foreclosures, but I do want to make sure that everyone understands. I believe that it's very, very important that you file an answer to these bank foreclosures because you may be superior to these bank foreclosure cases. So if it's a second mortgage holder, for instance, or a third mortgage or a HELOC loan that's foreclosing, you want to make sure that you answer that complaint and assert priority because they're going to try to say that they're superior to you and they don't have to pay you anything but the 12 months or 1%, when in fact you may have priority over them and they may have to pay you 100% of the money when they foreclose. But without actually looking at it and taking action and filing the answer, you'll never know. So again, you don't want to be penny wise and pound foolish here by not sending these bank foreclosures to someone to look at, because a lot of times there are things that can be done. Okay. Talked about that. Let's talk a little bit about the foreclosure process. It works just like what we talked about earlier for our foreclosure. Again, they work pretty much exactly the same. If a bank is foreclosing because you haven't paid your mortgage, they'll file a complaint against the delinquent property owner. That property owner then, after they're served, either personally or through publication, has 20 days to answer. If they don't answer, there's a motion for a default. If they do answer, there's typically a motion for summary judgment. And if either one of those aren't awarded by the court, then they'll be set for trial. So then typically either in our foreclosure or the bank's foreclosure, a trial date may be set and we'll actually have a full-blown trial on the case. A mortgage foreclosure trial is always before the judge. It's never before a jury because it's a case in equity. Now, if there's any additional actions, cross claims that are filed, if they sue us back or you're suing them for something other than just foreclosure, then the unit owner has the right to a jury trial. So, for instance, we may be suing and for an association, someone for foreclosure and for breach of contract. They do have the right for a jury trial in the breach of contract case. So even these small cases can sometimes end up before a jury. Okay. So after the property is sold, the certificate of sale has to be filed with the court. You have 10 days, or they have 10 days to object to the certificate and the sale. The only reasons that are valid to object to the sale is if somehow the property was sold for a lower price than it should, and that is a result of something, a mistake or confusion at the trial. Once that is done, the title's issued, and then they're the new owners of the property, and we would have to then start collecting against the new owner of the property. This is either in our foreclosure or the bank's foreclosure case. So why don't we I talked about all of these things. I kind of went through all of this. This 12-month payment or the 1% is called a safe harbor provision. Again, you want to make sure that you look at your documents and there's no provision in your documents that would change the safe harbor requirement. Also, you want to look in your documents to see if you have this thing called a Kaufman provision. You have Kaufman language. A lot of you may have heard that. Basically, Kaufman language just says that you're subject to the statute as it may be amended from time to time. And you want to make sure that you know, or your attorney at least knows, whether or not you have a provision that limits liability and whether or not you have Kaufman language to see what you're going to be owed from the mortgage company after the foreclosure. So with that, why don't we go ahead and take questions?
All righty. John, first of all, can you talk a little about selective enforcement? Because, many times one of my clients, one of the board members comes out and says, you know what, I want to go ahead and start collection process on these 10 individuals, but not on these other 4.
Yeah, so I don't really think selective enforcement works in the collections argument unless it's very, I usually don't see those as defenses in the collections area. Those are more defenses in violation suits. However, like I said earlier, one of the main reasons that we recommend consistency is that you don't have this type of argument that of selective enforcement. So we do want to treat everyone that's in a similar situation identically. So if you don't want to say you're going to foreclose against me because you don't like the way I look, but we're not going to foreclose against Mark because he's a good neighbor, right? So you do want to try to avoid that, but you can make decisions that aren't selective enforcement. For instance, I owe $1,000, but Mark owes $100. That wouldn't be selective enforcement. That's why I'm saying it's much more difficult in a collection setting.
Right.
It would have to be like for like, apples for apples.
Right.
Same thing actually in a violation. So while we're not talking about violations, let me point this out for selective enforcement issues, is that selective enforcement is the rule says no parking on the street, and I allow Mark to park on the street, but not John. It's not, the rule is no parking on the street, and I don't let John park on the street, but I let Mark paint his house purple, right? It has to be the same violation. It's not, it has to be actual apple to apple comparison for it to be a real selective enforcement.
Right. And I will share with the participants, and John, you'll remember this going back maybe 10, 15 years ago. You had a client and then you called us up and we were the receiver for a 94 unit property up in Palm Beach. and we redirected the rent. And by redirecting the rent, literally, we were able to go ahead and to collect and turn over to the association, I mean, a few $100,000 of monies that if we didn't do the redirection of rent, they would have just lost it. And it made the whole community very healthy monetarily.
Right. So, you know, the statute has a provision in it now that allows us to sequester the rent on a per unit basis. So if one unit is occupied by a tenant, we do have the right to just go in against that particular unit owner and send them a demand letter to pay us the rent. And if they don't pay us the rent, we can get an order from the court ordering them to move out. There are also options if you're in real financial difficulty, like that association was, Mark, that we can move for the appointment of a receiver. And in that situation, the receivership order actually allowed us as an association to go in and rent the unit. So there was a lot of vacant, and I know you remember, because you were the receiver, as there was a lot of vacant properties. It was a failed investor-owned community. And so it allowed us to go in and take these vacant units, rehab them, put in a renter and rent the properties and allow the rent to be paid to the association, where they could then use to fund the operation of the association. So there are other options if you're in that situation, such as receivership.
We have a question. How can a property manager check if the unit owner filed for bankruptcy?
Yeah, so there is, it's kind of difficult for the property manager to actually check. You should be have received mail. So when we're talking about the property manager alone, the property manager and the association will receive notices from the bankruptcy court stating that there's been a bankruptcy filed. And the big problem I see is that most property managers don't keep good track of that information. They've been noticed of the bankruptcy and they kind of circular file, or they just throw it in the unit owner's file and they don't understand the significance of it. A lawyer can certainly check because there's a website that is available to us. I believe as a property manager, you can also, it's free, but you would have to fill out the form with this federal government. It's called PACER, PACER, and you can get a login to check on PACER, and then you log on to the PACER and you can check to see if that person had filed for bankruptcy. And then if you print anything, there is a print charge. So you do have to associate a credit card with it. But that is possible, but you have to register for it.
Okay, then we have another question. Can you charge the unit owner the cost of sending the certified letter?
Absolutely. But what I was referring to earlier, why it becomes expensive for the association, is remember, we're sending these letters to people that already aren't paying. So we're not going to get this certified letter cost back until the end of the matter when they pay. So you're putting the money, you're fronting the money, and then getting it back in either the foreclosure or when they pay it, when they settle.
All righty. We have another question. If you foreclose and someone buys at auction, how do you get the money from the person that had no idea of money owed if you didn't file a lien?
Yeah, so I'm going to change the question around a little bit. So if we foreclosed as an association, then we had to have filed the lien. So there's always going to be a lien when we foreclose. I do want to make sure that everyone understands that. So I'm going to answer this in two ways. If it's the association that's foreclosing and we have a judgment and the property is sold at auction, that property is then paid directly to the clerk of court, and then the clerk of court issues a check after the certificate of title has been issued. They then disperse those monies through what's called a certificate of disbursement to whatever address you've set forth in your foreclosure judgment for them to pay the money. So typically your attorney, that those checks are then sent to the law firm, or if not the law firm, they may be sent to you directly as an association. But those funds come directly from the clerk of court. So the clerk collects it, and the clerk pays the person that the association has directed. The bigger issue is that if a bank is foreclosing on their mortgage and you have not filed a claim of lien, how does that person know who to pay? And the issue there is that all of your declarations have been recorded. And so that puts everyone in the country on notice that you are the association and that they would then have to pay you the past due maintenance. But again, you have to look to see if there's any provisions in your documents that limit liability. And if it's the first mortgage company, then they only that buys at the foreclosure sale, they only have to pay 12 months or 1% of the outstanding mortgage. But if it's a third party that buys it, they would owe you 100% of what's past due. It helps if you have a lien because then they see it and they know it and they're well aware of it when the foreclosure happens. But even if there's not a lien, they would still have to pay you because you have a recorded declaration that gives you priority.
All right, terrific. I have a problem with my camera, so I'm not going to be able to have my my face shown. Is there any other questions from the audience right now? I answered the few questions that came up. So we have another few more minutes to.
Oh, yeah. So I see
one just came
more
up from
question.
Sue.
Yeah. So, what happens if the owner appeals a judgment that is in favor of the association? So unfortunately, this does happen. I have a few of them going on currently. You have to then argue the appeal. So appeals typically are not oral arguments like most actual circuit cases or county court cases. The bulk of the argument is done orally. We file motions and then we have hearings. With an appellate court, you're filing appellate briefs. So typically, if someone appeals the judgment, the property would still typically be sold at the foreclosure unless they get a stay of the sale. In order to stay the sale, the judge typically is going to require them to post a bond in the amount of your judgment. The bond and the amount of the judgment would then be payable to you if they lose the appeal and they don't pay you. You would then go and they would file their brief, and then you would have a limited period of time to file an answer brief. Once you filed an answer brief, they can then file a reply brief, and then the appellate court decides whether there was an issue at law that would allow for the appeal to occur. And then if the judgment is then either sustained or overturned, if the judgment is overturned, it's typically sent back to the lower court and they're told to, try again another time.